Today's podcast critiques the Punjab and Haryana High Court Chandigarh bench judgment involving the All India Bank Retired Officers Federation AIBRF. Over the last 2 weeks, we covered the Jaipur and Delhi judgments, and both judgments favored retirees' demands for pension updation. And DR, I'm Priya Chakraborty, and my co-host is Anil Agrawal.
The Chandigarh judgment is important because of its national legal significance in shaping the pension parity debate now under scrutiny in the Supreme Court.
The All India Bank Retired Officers Federation, representing thousands of officers retired from public sector banks, PSBs, prior to and post the year 2002, filed a constitutional writ petition under Article 226 of the Constitution seeking remedy in 3 areas.
Number 1. Pension updation. In alignment with successive wage revisions conducted under the bipartite settlements negotiated between the IBA, bank unions, particularly the 10th and 11th BPS.
Number 2, 100% Dearness relief, DART neutralization for pre-November 2002 retirees who were receiving DR on a discriminatory basis.
Number 3. A declaration that Regulations 35(1) and 56 of the Bank Employees Pension Regulations 1995 required periodic pension revision as an enforceable right.
The petition civil writ petition, CDP number 1-8 2018, filed against the Union of India, UI, the IBA and multiple PSBs, argued that the failure to update pensions violated Articles 14 and 21 of the Constitution, causing unjust deprivation and economic marginalization of older bank retirees. Furthermore, the writ argued a violation of established precedents such as DS Nakara v. Union of India 1983.
And this case is crucial because it addressed the heart of the injustice to the elders of India's banking. The court's judgment, delivered on 9 October 2023, was expected to clarify the scope of pension parity, the binding nature of IBA procedure, and the role of the central government in approving pension revisions.
In the event, the Chandigarh bench dismissed the petition, taking a cautious and deferential approach to government policy and fiscal discretion. The judgment was appealed and is one of the key cases consolidated in the Supreme Court's ongoing MC Singla pension parity proceedings.
The injustice suffered by bank retirees is rooted in the clash between the courts recognizing economic hardship, seeing unfairness, but then feeling powerless to actually force changes in government spending or policy on updation and DR.
The court explicitly mentioned perceived inequities faced by these bank retirees. They saw the problem, and yet the final verdict, no positive relief. Case dismissed, no remedy.
Wow. So they acknowledge the unfairness but don't order a fix.
Right. That's the paradox we need to unpack. Why would a court do that?
Let's break down what AIBRF was asking for. They had 3 central complaints against the Union of India, the Indian Banks Association, and the banks themselves.
First big one, they wanted their pensions updated. They argued pensions should automatically rise whenever salaries for current employees go up to the current bipartite wage settlements negotiated after 2002.
That's reasonable. If active salaries increase substantially, why should pensions based on older scales stay stagnant? The BPS agreements happen roughly every 5 years and often involve significant pay hikes that left retirees dramatically behind.
Okay, what was the second complaint?
This one was about Dearness relief, or DR. That's the bit meant to offset inflation. And they argued it was being applied completely differently, unfairly, just based on when you happen to retire. A real source of inequality.
And the third point?
That was the core legal question tying it all together. Did Regulation 56 of the 1995 Bank Pension Regulations actually create a binding duty, a legal obligation for the banks and government to keep updating pensions? Or was it more like a suggestion?
Okay, let's tackle the Regulation 56 issue first. Was it an automatic trigger for pension hikes every time a BPS deal was signed? Did it mandate revision?
Well, the court looked closely at Regulation 56. They agreed it was there. And yes, the intention was probably to allow for future updates to provide flexibility.
Right?
But, and this is the crucial finding, Chandigarh bench ruled the regulation was permissive and flexible, not constitutive of an enforceable right. meaning it gave the government and banks the option to revise pensions, maybe even suggested they should think about it. But it didn't legally force them to. There was no automatic command baked into Regulation 56.
So the court couldn't just order them to update the pensions based on that regulation alone?
No. The court explicitly stated, unless the Government of India or the Indian Banks Association frames a specific scheme for pension updation, the court cannot mandate wage pension parity.
So the mechanism, the actual plan for updating, has to come from the government or the banks themselves. The court won't invent it.
Precisely. It has to be what they called executive action, negotiation, policy decisions, budget allocation. That's not the court's job in their view.
You mentioned earlier that pension is seen as a deferred wage, citing the famous DS Nakara case. That sounds like a strong right. How did the court square that with refusing to enforce updates?
That's the subtle legal dance. They acknowledged Nakara. Yes, pension is a deferred wage, a right. But then they leaned on other precedents like WPIL, LTD v. Union of India.
And what did that say?
Those cases basically draw a line. They say, yet you have a right to your pension, but the specific formula used to calculate it or revise it falls under policy making.
So the right exists, but how much you actually get and how it changes over time, that's policy.
That's how the High Court interpreted it. They said, we recognize the right, but creating the whole mechanism, the actuarial work, the budget impact across all banks to enforce a new revision formula, that's beyond our scope. That's for the executive.
That feels like a tough pill to swallow for the retirees. Entitled but no guaranteed update.
It really sets the stage for the next issue, which the court found even more problematic.
Okay, let's move to that second point then, the Dearness relief. You said this is where the court explicitly acknowledged disparity, even called the situation troubling.
Right. This is where the unfairness becomes incredibly stark. It all hinges on this one date, November 2002. If you retired after November 2002, your DR is calculated using a modern method. It aims for full neutralization, meaning it tries to fully compensate for year-on-year cost of living rise.
Sounds fair enough. What about the others?
If you retired before November 2002, even just a day before, your Dearness relief is calculated based on a frozen base index from 1986.
Wait, say that again, 1986?
Yes, 1986. So your cost of living adjustment is essentially pegged to price levels from decades ago.
So for things like rent, food, basic necessities,
Yes,
their adjustment is based on costs from the mid-1980s, is that right?
that's the practical effect. Imagine two colleagues, same job, same career length. One retires October 31st, 2002. The other November 1st, 2002.
Okay,
The first person gets DIR based on 1986. The second gets a modern full neutralization. The difference in their actual pension amount grows wider every single year as inflation continues.
that's astonishing. It seems fundamentally unequal.
If the court called it troubling and acknowledged perceived inequities, why didn't they step in? Didn't the retirees argue this violated the Constitution, like Article 14 for equality or Article 21 for the right to life and dignity?
They did. They made strong constitutional arguments, and this is where we hit that wall of judicial reluctance again.
Despite finding the distinction troubling, they refused to strike it down. They invoked something called institutional modesty.
Institutional modesty, what does that mean in this context?
It means the court felt that intervening would require them to fundamentally redesign the financial structure of the pension schemes for the entire PSB sector.
The court also pointed to huge potential costs, financial sustainability, actuarial assessment, and cross-sectional impact. Fixing the DR for all pre-2002 retirees according to modern standards would likely cost billions. So they're saying, hey, we see the unfairness, but fixing it involves massive budget decisions, and that's the government's job, not ours.
That's how this High Court judgment landed. They prioritized deference to policymaking over enforcing the Constitution. That should concern every Indian citizen.
Okay, so let's talk about the outcome. The petition was dismissed, no direct order, no mandamus. What does this actually mean for the retirees now? It sounds like a loss, but you mentioned a ray of light.
It was a loss because retirees didn't get the court order they wanted, but crucially, the case was dismissed without prejudice.
What does without prejudice mean?
It means the legal issues aren't dead. The retirees aren't barred from raising these same arguments again, perhaps in a different form or context. The court didn't say their claims were wrong on merit, just that this court wouldn't grant the specific relief requested.
Okay, that's important.
And even more importantly, the court didn't just dismiss it and walk away. They included language specifically inviting the government, the Union of India, and the IBA to re-evaluate the whole pension updation and DR parity situation.
So they pointed the finger back at the policymakers.
Directly. They basically said, look, we see the problem, especially with the rising cost of living. The defendants need to go back and seriously reconsider this scheme. They documented the injustice and then essentially challenged the executive branch to fix it.
That context makes this High Court ruling feel less like an endpoint and more like setting the stage for something bigger. You mentioned a Supreme Court case, MC Singla v. Union of India. Does this ruling feed into that?
Yes, this High Court judgment is quite valuable for retirees at the Supreme Court. It acts as a perfect springboard.
How so?
Well, think about it. If the High Court had actually granted relief, the Supreme Court would just be reviewing whether that decision was correct. But because the High Court acknowledged the unfairness, particularly the DR issue, but then denied relief based on institutional modesty.
It creates a clear conflict for the Supreme Court to resolve.
Exactly. It does three things for the MC Singla case. First, it provides an official judicial record, acknowledging the systemic unfairness. The facts are no longer just the petitioner's claims. A High Court has recognized them.
Okay. Point 1. Validated facts.
Second, this judgment perfectly represents the conservative interpretation, the current status quo view, where courts differ on fiscal matters. The Supreme Court can now look at this specific reasoning, the institutional modesty argument, and decide if it holds up.
So it frames the exact legal principle the Supreme Court needs to rule on. And the
Third, it presents the perfect test case. It forces the Supreme Court to grapple with that fundamental question. When does judicial restraint, this institutional modesty, go too far? When does it effectively allow a violation of the Constitution, the right to a dignified retirement funded by deferred wages, simply because the fix involves money?
Right. Does deference to policy override a constitutional guarantee?
That's the question. Chandigarh has laid out the entire problem, acknowledged the pain points, but stopped short of ordering a solution due to fiscal concerns. Now the Supreme Court can decide if that's the final word.
Okay. Let's synthesize this. The key takeaway for you listening is that the Punjab and Haryana High Court basically said pension updates are needed. The DR difference looks unfair, but Regulation 56 doesn't automatically force it.
Right. The court saw it as enabling, not mandatory, which puts the responsibility, the onus squarely back onto the government and IBA to actually create and fund a fair scheme. The power to fix it is there. The mandatory legal order, at least from the High Court, isn't.
So let me leave you with this final thought building on what the High Court itself observed. They said classifying retirees based only on a cutoff date is inequitable.
What if the Supreme Court, looking at the MC Singla appeal, takes a different approach? What if they say that Regulation 56, even if not explicitly mandatory word for word, carries an implied obligation?
If a pension is truly a deferred wage, a fundamental right, doesn't that right itself imply a duty on the part of the employer or state to protect its value against predictable things like inflation? Could that bypass the whole "it's just fiscal policy" argument?
If the Supreme Court found an implied obligation inherent in the nature of the deferred wage itself, or perhaps in Regulation 56 read purposively,
Then the excuse of it being purely discretionary policy starts to crumble.
it could, potentially. It would shift the ground significantly. suggesting the duty to maintain parity isn't just optional, but flows from the Constitution itself. That's the big question hanging over the MC Singla appeal. That's the potential legal earthquake we're all watching for now.
We will keep tracking MC Singla case in the Supreme Court. Our next podcast on November 14 will cover AIBRF v LIC.
Thank you for watching. Please like, share, comment, clip, and subscribe. Until the next time.